Hello and welcome to the Media and Privacy Laws in South Africa. The purpose of this presentation is to take a broad look at privacy laws in the South African media space, especially in light of the fact that the Protection of Personal Information Act will soon be fully applicable in South Africa. This presentation is presented by Helene Viljoen. I am the legal advisor of Caxton Local Media, and the Forum of Community Journalists specifically requested this presentation, and it's also made available to the Press Council of South Africa. The issue of privacy is a conundrum in its own. Each privacy issue is judged on its own merits, and social media has not made things any easier. When someone posts something onto social media, we often share without thinking about privacy. Sometimes we make things available to the public, sometimes we make it available to our friends, and people often, for example, take a screenshot and share it without thinking twice. Today's training will do exactly that. Think twice or more than twice about privacy and the media realm. We'll give you tools to help you judge tricky situations involving the right to privacy fairly. We'll deal with the right to privacy and the right to freedom of expression. The Press Code on Privacy will be discussed, as will the Protection of Personal Information Act in a journalism context. We'll look at privacy during news gathering and lastly, privacy during publication. There are two competing rights that are constantly being weighed up if you're a journalist. That is the right to privacy on the one hand and the right to freedom of expression on the other. And jurists often use this image to illustrate the competing rights that are constantly navigating our everyday activities. The balancing act that we perform is central to today's discussion. The Protection of Personal Information Act for newsrooms. We process a lot of personal information every day. What is personal information? It's a very broad subject. In short, if the information takes me to you, it's personal information. What do I mean by that? Your identity number takes me to you. It links me to you in a way. Your cell phone number does the same, as does your address. Your business registration number and car registration number are two more examples. There are some terms that are thrown around quite regularly when we deal with personal information, and especially when we deal with the Protection of Personal Information Act. And that's the purpose of this slide, is to illustrate the legalese for you, to illustrate some terms that feature in the POPIA Act. Just a note about the acronym, you'll hear the term POPIA or POPIA. The information regulator is the body in South Africa that adjudicates and deals with the implementation of the Act, and they prefer the acronym POPIA. So we're going to be using that. The terms that we're going to be dealing with in this slide are data subject, personal information, responsible party, and operator. These terms are legalistic terms, and they are used in the Act. So when people discuss the POPIA Act, these are the terms you're going to be hearing. Although you won't necessarily be using them in your day-to-day functioning as a journalist, you should know what they mean. We're going to be illustrating them with reference to the well-known case of Tshabalala Msimang and another versus Mkanya and others. Many of you will remember this. It's a case that dates back to 2007. Sunday Times had medical records relating to the late Dr. Tshabalala Msimang, and you will recall that she was our Minister of Health at the time. The medical records showed that she had been drinking alcohol while she was admitted to a private hospital on the taxpayer's dime. Following publication of a story based on these medical records, she obtained an interdict against the Sunday Times, barring follow-up stories. The Pretoria High Court considered two basic human rights. The one is the right to privacy, which obviously she had, because we all have a right to privacy when it comes to our personal information, such as our medical records. So the court considered this right on the one hand, and on the other hand, the court considered the right to know, or the right to freedom of expression. So the court considered these two rights, they did a weighing up exercise, and in the end the court found that in this case, the public's right to know that the Minister of Health, who was hospitalized on the taxpayer's dime and who was drinking alcohol while admitted to private hospital, that the public's right to know that weighed heavier than her right to privacy as it related to her medical records. So with this example in mind, I want you to remember those legal terms that we referred to. In this example, the data subject, in other words, the person to whom the data relates, was Dr. Chabalala Msimang. She was the data subject. Her medical records was her personal information. So with this example in mind, I want to take a few steps back and take you back to this scale. There are some terms that we use a lot. The right to freedom of expression is one, and the right to privacy is another. And then you have the scale. And then the term public interest comes into play. We'll be defining that in a moment. But for now, I want you to use this Dr. Chabalala Msimang example and imagine that the public's right to know, exercised through the media's right to freedom of expression, imagine that the value of that right was placed in a basket on the scale that you see on the left-hand side of the screen. The value of that right to know was placed in a basket on the right to freedom of expression side of the scale. And the value of our former late health minister's right to privacy and the expectation that she had that the privacy of her medical records be respected. The value that she attached to that reasonable privacy expectation, imagine that that could be quantified, put in a basket and placed on the right hand of the scale. If you could conjure that up in your mind and imagine that you were the judge and you performed that balancing exercise. In this case, the court decided that the imaginary basket on your left-hand side of the screen weighed heavier. The public's interest in that information weighed heavier than her reasonable privacy expectation relating to her medical records. Now, with that in mind, I want to move on to the POPIA Act specifically and what you should know as a journalist. So the POPIA Act has a lot of legalese. As I said, it has a lot of definition and it's pages and pages of theory, but here is what you must know as a journalist. If you subscribe to the press code, and if you follow those rules, then you are subjected to Clause 4 of the South African Press Code and not the POPIA Act itself. What does this mean for you? This means that if you process personal information for the purpose of journalism, then you need only follow the following rules. Number 1, limit the personal information that you collect and use to what is necessary for the purpose of news gathering and news reporting. Secondly, store the personal information that you have for the purposes of news gathering and reporting safely. Thirdly, don't distribute the personal information in your possession except if it is absolutely necessary, once again for the purpose of lawful and ethical journalism. Once you are done with the personal information in your possession, destroy it. And lastly, never publish personal information unjustifiably. And we are always guided by news in the public interest. That is why we do what we do. So if you publish personal information, it must be justifiable for the reason of journalism in the public interest. To summarize this slide, if you collect or process, in other words, use personal information for the purpose of journalism, you're subjected only to Clause 4 of the Press Code and not to POPIA. And these bullet points are what you must keep in mind as a journalist. So if you have not yet printed out Clause 4 of the Press Code, or preferably the entire code, please print it out, put it up next to your computer and ensure that you read it and make it your own. That way you will ensure that you do things the right way. This is a copy of Clause 4. You can screenshot it if you'd like and ensure that you save it somewhere. Otherwise, you can just Google South African Press Code and ensure that you copy and paste the entire code, or specifically in this case, Clause 4. Okay, so this is the theory. We will now put it into practice. So how do I do my job as a journalist and as someone who subscribes to the press code while keeping in mind South African privacy law and POPIA and the press code? As said before, we always perform a balancing act. On the one hand, we have the right to freedom of expression. On the other, we have the right to privacy. If you want to take a photo or take a video, here are some things that you need to keep in mind. It's always a case-by-case consideration. So you will consider taking each photo and video on its own merits. But there are some general principles to keep in mind. Don't identify minor victims, accused, or witnesses in court proceedings. You will remember the Zephany nurse case that ended in the Constitutional Court. In general, there is a great privacy expectation when it comes to minors. So if you want to take footage of a minor, video a minor, take a photo, ideally find the responsible adult, be that a guardian or parent, and get their consent. If you go to a school, if a school invites you to take photos or videos, and that school's POPI policy is in place, and the school invites you, allows you to take photos, then that means the school, in its position as guardian of its pupils, have authorized you to take photos of the pupils at a certain event that you may have been invited to. If you are asked not to photograph or video a certain pupil, please adhere to that requirement. In public, we can generally take photos, take video footage. Remember that if the photo or video that you take depicts any incriminating behavior, you must always offer the right of reply to those involved. The less public a location, the more the reasonable privacy expectation of those that may be photographed or videoed at the location. And if that's the case, there's an increased need for you to respect the subject's reasonable privacy expectation. Remember, there's a difference between taking footage and using it. We'll get to using the footage in a second. Calls and voice notes. You can record a call or a voice note if you're a party to the conversation, but you cannot publish it if you have not given everyone in it and everyone referred to in it the right of reply. Now we get to publication. So remember we said before you take a video or a photo, you consider someone's right to privacy. You do the same before you publish. How do we determine when it is justifiable to publish? Firstly, we asked, does my subject have a reasonable privacy expectation? Secondly, you asked, what is the public interest at play? You will ask whether the public interest demands and justifies an infringement on the subject's right to privacy, and if so, in what measure? Now, these are many theoretical questions, and they will be much better illustrated in practice. This may be a very silly example, but what is a reasonable privacy expectation? This man is an adult and he is streaking in public at a cricketing match, which probably is an event in the public interest. Does he has a reasonable privacy expectation? I'll say no. This person, on the other hand, is taking a shower in his home. He definitely does have a very large reasonable privacy expectation. And for reference, we will go back to our former late health minister. She had a reasonable privacy expectation relating to her medical records, as we all have. But the fact that someone has a reasonable privacy expectation relating to something does not necessarily mean that information to which that privacy expectation attaches will not be published. Public interest will come into play. Before we get there, however, I want to discuss how someone's reasonable privacy expectation is reflected on social media. If you look for something to use from social media, always let privacy settings guide you. If a post has no copyright issues attached to it, in other words, if it a photo, for example, has been posted by a professional photographer, I would not advise that you just blindly share it, because there's copyright in creative works, and especially a photographer, for example, will take exception to you merely sharing their work. If an image has been categorized as publicly available, then you know the person who shared it and the person who made that image available said, I have no qualms with you publicly sharing this image. On the other hand, if I share an image of myself and I mark it available to my friends only, that indicates that my privacy expectation is for this photo to remain between friends. Please take note of that. Remember that I can be public about my own information, but if I post a photo of my children, for example, they have their own right to privacy. My husband has his own right to privacy. And ask yourself, is it really my right? I'm Helene Viljoen. If I post a photo of my husband, can I really decide what his reasonable privacy expectation is? I'd say the answer is no. So if you want to take a photo off of social media, ensure that the person depicted on the photo is the person who posted it and that that photo is made publicly available. Before you simply take it, also consider copyright issues. What is public interest? You'll remember that we asked, one, does someone have a reasonable privacy expectation? We consider that. We consider public interest before deciding whether or not to publish. Public interest as defined in a hard news or serious matters context. Now, there is no one hard and fast definition that has been generally accepted. I like this one. Something is in the public interest if a member of a community must know it in order to make decisions as a properly functioning member of that democratic society. Examples of information in the public interest could be info relating to corruption, crime, events of significance on public roads or public places, and criminal or unjustifiable acts by those in public office. You'll note that the threshold for hard news or serious matters is rather high. Information is in the public interest if a member of a community must know it in order to make decisions as a properly functioning member of that democratic society. Here's a good example, and I'd like you to consider this for a few minutes, of information in the public interest where privacy rights of residents had to be considered. Drugs worth 154 million uncovered at upmarket Belita Estate meth lab. So there was quite an upmarket estate in the Belita area, and one of the residents in one of the homes decided to cook meth. What's the reasonable privacy expectation of other homeowners in that estate? Do you name the estate? Why would you decide to name the estate? You can look at these questions and consider the reasonable privacy expectation of the offender as well as other homeowners in the area and have a discussion about what is fair. You will quickly learn that there's maybe more than one answer to a question. If you would like to deliberate on this, please feel free to pause the slideshow and discuss amongst yourselves. The public's interest requires us to think twice before we act. Do not simply publish unverified info, unconfirmed suspects that people on social media share without contacting the police or verifying the identity of said suspects. Note that some footage that people share before thinking online could ruin ID parades or police investigations. That is why the duty is ours to verify before we publish. The definition of public interest, as I said, is not hard and fast, and it could have a lower threshold when it comes to good news. Something could be in the public interest if my community members would like to know it, and if airing it would not unjustifiably infringe upon the privacy rights of the subjects involved when it comes to good news. Good example would be, let's say, a local lady wins a flower contest. Publishing that photo would be subject to a lower public interest threshold than when it comes to hard news, and then the subject would have a higher reasonable privacy expectation. I'd like to know that Sari Sitole attended the Vryfees, for example, but if she does not want her photo published, the public will not likely suffer as a result. Although a photo of her with an ice cream would be nice on the front page, I can delete it upon request. On the other hand, if a robber is caught red-handed and I happen to be there in public taking the photo, if the robber says, "You're not allowed to publish my photo," chances are that I'll probably say, "No, sorry sir, caught you red-handed in public, I'm publishing the photo." This is an example that Sanef dealt with a few years ago. And you can consider this for a few minutes. Once again, if you would like to deliberate on this, please feel free to pause the slideshow and take 5 minutes to discuss. Lastly, I would like to use the "Am I publishing this?" test, and I would like you guys to use it too. I think it's very handy. If you have a video or information or a picture and you can't decide whether or not to publish, the first question will be, is this in the public interest? If yes, proceed to take this test. If no, you won't be publishing it. If you've decided that the information is in the public interest, ask the following question. Does the subject have a reasonable privacy expectation? If the answer is no, and the information is in the public interest, publish. If the subject has a reasonable privacy expectation, public interest comes into play, and we ask, does the public interest require publication and why? Once again, our very handy example of Dr. Manto Chabalala Msimang comes into play. Was the scenario that the Sunday Times published in the public interest? Absolutely. Did she have a reasonable privacy expectation? Yes. Did the public interest require publication? Yes. They then went ahead and published, and the court agrees. That concludes this presentation, and I hope it was helpful.